meeting about?
Can you see this PowerPoint?
No, no.
Oh,
So
Yeah.
okay. I've done a PowerPoint, but it looks like I'm not quite sure how to share it.
no, it's quite easy. So be patient. So open up the PowerPoint document first of all.
Yep, it's open.
Lovely. Then at the bottom of your Zoom window, you should see a little green rectangle that says share on it.
Yeah.
Click on that one,
Yeah.
and
And
either F is saying hello and maybe in the wrong meeting. I've got no idea either. Is the honest answer. Why don't you have?
She'll need permission for you to share a screen, so she'll need to be
Yeah,
co-host.
she's already got permission. We have that. So you should be able to share the screen now, Rosie. So share your screen.
okay.
It's not
Oh.
coming. It's not coming through. Here's an alternative, Rosie. If you email me the slide deck now, I will open it for you at this end if you want me to do
Brilliant.
that.
Thank you very much. That's really helpful.
While you're doing that, why don't you just kind of talk around what we're here to talk about so that either F and others know what we're here for, okay?
Okay. I'm just emailing you. It's coming through now.
All right, lovely. That's good. Thank you.
Send anyway. It doesn't have a title on that email.
That's okay. Don't worry.
So the meeting was called because we've been working with Deborah and her group, the SSB victims. And what has come out of that is that we've realised that both groups are Novitas rate setter loans victims, and the SSB victims are also impacted very negatively by litigation loans. Now, I stumbled upon the fact that the government is holding a consultation relating to litigation funding. And I had a look at what the scope of that consultation was and who were involved in the consultation, and noticed that it didn't include any consumer voices or victims' voices.
Right.
If the PowerPoint has arrived with you, then I can maybe gallop through it, because it really is a sort of so
Yeah,
I think this is self-explanatory. We're expressing concern that the government consultation on litigation finance does not include victims' voices, consumer voices, or representatives of charities such as Shelter, Mind, Citizens Advice Bureau, and the Citizen and Step Change, who have assisted victims of these problem debts. And then
when you want me to go to the next slide, just say so, Rosie.
Next slide, please.
Okay, so can you see we've got it on the screen? Okay, thank you.
Okay, next slide.
Yeah.
So I've just done a really brief summary of a few cases that have reached the press. This is not exhaustive at all. There are so many stories about litigation finance that are verified and that are really worrying. So this one is pure legal, 150 clients affected and trying to recoup crippling losses. At the bottom of that, pure legal was funded by Novitas rate setter and was pretty much a Novitas rate setter construction, with the directors of Novitas rate setter also being directors of pure legal. So pure legal collapses a lot of victims. Next slide.
Okay.
This is me. This is Novitas, in my case, unaffordable lending, and that was found by the Financial Ombudsman. Next slide. I'm really sorry, Deborah. I don't know why this is so dark, but this is Deborah and her group. These are people who were encouraged, even door knocked, to take out cavity wall insulation claims with various legal firms, Seth Lovis, Pure Legal, High Street Solicitors. Most of them were sold Novitas loans. All of those firms went bust pretty much, or were closed subsequent to intervention. And all of those loans bounced out into SSB law group, which is now also closed down. So these loans bounce on and on and on, and they don't actually resolve any of the problems that they were taken out to resolve. And in fact, these victims have suddenly found that they've got orders for costs made for cases that they thought and had been told had been dropped. But I'll let Deborah talk about that later. The next slide. This is a couple pure legal again, potentially part of Deborah's group. She would know better than me on that. Pushed into bankruptcy as a consequence of pure legal and the sale of these litigation loans. Next slide. So who are the consultants? And this is where I initially just thought it's a bit worrying. There aren't really any consumers or consumer organisations involved in this consultation, but the end target for these litigation loans is us, the consumer. We're the ones left with the debt. What you have here is a very august group of mainly solicitors and one representative from the Financial Conduct Authority. Sorry, I said solicitors, I'll correct myself. I mean lawyers, barristers, and solicitors.
Yeah.
Solicitors have a vested interest in litigation lending. It's a very, very profitable thing for them to sell a litigation loan. Then they can charge fees against the litigation loan. And actually, victims' experience is that they then lose very much control of the whole litigation process and how their money is spent. So if we move on, those are the people. So aside from representatives from the Financial Conduct Authority, they're commercial lawyers. Next slide. The first person and co-chair is Mr. Justice Simon Picken. And just the most brief bit of digging uncovers that he was very recently sanctioned given a formal warning for misconduct. Okay, that's a bit of a shock, but it's not necessarily a game changer. It's just a little bit of a red flag. Next slide, please. Nick Bacon, KC, was a non-executive director of Pure Legal. He was at the helm when this firm collapsed. And he is one of the consultants who is effectively in a position now, as I understand it, to write law relating to litigation finance. Next slide. Christopher Hodges, and I have no doubt these people are wonderfully well qualified and very important people. Professor Hodges is a chair of the Horizon Compensation Advisory Board, advising the government on compensation for post office workers. Now, one of the things that's come out of that is that for every £1 that any sub-postmaster has received, £2 has gone to a lawyer in the compensation scheme. So that is a little bit of a cause for concern. I'm sure he's doing a brilliant job, but at the same time, that's something of a red flag. Next slide. Lucy Castledine is the Financial Conduct Authority lead on this consultation. And on her LinkedIn profile, she said that she led the FCA's dual regulated department in authorization subdivision. I understand this to mean the interim permissions register. And she does say she was involved in authorizing fintech companies. We come back to our old friend Novitas, who are funded by RateSetter, who were a P2P fintech and who were given interim permission by the FCA, despite a lot of red flags. In fact, they had to be sanctioned quite a few times for hiding bad debt, and for selling their loans via Novitas, which amounted to the illegal acceptance of deposits. The Chief Executive Officer of the Financial Conduct Authority did a Dear CEO letter relating to that and broke all of those links. but this had been going on for several years before any intervention happened. So there were lax controls around the interim permission register. I'm not saying that Lucy Castledine was responsible for that, but it would appear that she had some form of oversight of that function. And it's a bit worrying that she too is effectively in a position where she can begin to write law relating to litigation finance. Next slide, please. So I was going to go on to Mark, who can talk directly about the next harm, which is litigation loan fraud. He has personal experience of this. So, Mark, do you want to take over at this point?
Yeah, I can tell you that gentleman is Mr. Christopher Bilmus, who was a solicitor at a firm he set up called Bilmus LLP. And he obtained a Novitas litigation loan on behalf of my partner, with whom I worked in helping the police put a case together for the CPS. And one of the several counts of fraud by abuse of position to which he pled guilty was fraudulently obtaining a Novitas loan on behalf of Hanukkah. Was alarmingly, with the greatest of ease. He simply, all he had to do, she was on maternity leave with very little income, and all that was required of him to qualify for the Novitas litigation loan was an application form in which he fraudulently misrepresented Hanukkah's marital status and said we were married. The CPS referred to that extensively at his sentencing, saying, had he accurately described her as my partner and not my wife, it's very unlikely he would have got the loan. But the important point is that I too applied for Novitas funding, and both loans were approved, managed by the same person, Mrs. Emma Reeves, director, co-founder of Novitas, and there's no way that she could have failed to notice that one application described Hanukkah as my wife and the other described her as my partner. So at best, Novitas themselves fraudulently proceeded to approve both loans, or at worst, fraudulently proceeded to approve both loans, or at best were negligent in not doing due diligence on the applications.
So litigation loan fraud, I haven't put together all of the examples of litigation loan fraud that we have found, but there are so many of them. It's really quite shocking. Firms that you've had multiple solicitors jailed for litigation loan fraud. It's a big problem. It's not, this is one example, and Mark has personal experience of this particular one, but there are lots and lots more. I did send to the CJC an expression of interest, asking if we could have consumer voices, charities, and victims' voices heard in this consultation. They were inviting expressions of interest, and this morning I received the response that no, you cannot take part in this. We've got all the people that we want to take part, and we're confident that the people we've chosen, those people I've quickly gone through earlier, are the right people for the job.
Has that correspondence come from the SRA?
No, it's come from hang on, I can check exactly who sent it, but it's from the CJC. Let me just see.
Are they explicitly stating that they don't want you or similar organisations to respond to consultation?
I just need to find it. I'm really sorry, Andy.
That's okay. No need
I
to
kind of
apologise.
shot myself in the foot doing a presentation because I've never done one before, but I really wanted to sort of show.
You've done a good job. You've done a very good job.
It's my first. So, but let me see. It just came in this morning, and I copied it on to Deborah. Here we go. Da, 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 da. Did I forward it by email, Deborah, or did I forward it by WhatsApp?
Deborah
by
Pump's stuff,
email.
yeah.
Okay, so if I find that.
While you're finding that, Rosie, can I just go to the last slide and we can close the slide deck down?
The last slide is just thank you to
Okay.
Deborah for joining with us, and to everyone for coming. And it's just who to contact, basically. So Deborah or me, if
Okay.
anyone wants to get in touch. Oh, one other thing. As I was preparing that presentation, I saw an article by John Hyde at the Law Society Gazette, who I can see is on the call as well. And thanks very much, John, for your interest. And it shows that there's yet another of these claims management companies gone bust with debts owed to litigation loan funders. And I think it was 57 million, the one today,
Wow.
that's gone bust. So it's a house of cards.
Understand. Rosie, partly for my benefit, just to make sure I've got my thoughts kind of lined up in my head correctly, and potentially for the benefit of anybody else, can I just kind of summarize what I believe you've been saying to me based upon this conversation and conversations we've had in the past, and then correct me where I've gone wrong in the way, okay?
Okay.
So my way of framing would be to say that law firms are commercial entities that are highly motivated to make as much money as possible. They exist first and foremost as profit-making entities for their owners. They do many things to make a lot of money. Many of them are very successful at doing that, of course, and many of them are huge. And one of the things they do is to organise litigation loans for whom these litigation loans are a win-win. On one hand, they make a lot of money off the back of their involvement in organising the litigation loan, a huge amount of money. And secondly, because of the litigation loan, they have a client who now has a lot of money to spend on their services. So it's a win, it's a double win for them.
Yes.
All of that would be hunky-dory if it was all being done in a fair, equitable, transparent, truthful, trustworthy way. But the reality is that's not the case. The reality is it is a highly exploitative situation where typically vulnerable people, for example, a lady going through divorce, finds herself or himself in a situation where they have a desperate need to get justice. They may be commercially minded about that need for justice. They may be emotionally driven about the need for justice, but they have a real yearning to make the right thing happen in the law. They realize they can't do that without the money to pay a lawyer. And when a lawyer says, we can solve that for you, what you need is a litigation loan, they are highly predisposed to say yes. And probably by that stage, having opened up their hearts and souls to the lawyer about the case in question, they find themselves in an emotional situation where they perceive this lawyer to be trustworthy, who has an interest in their well-being, who's going to fight their corner for them, may already have sort of hero-like tendencies, and inevitably many, many people will be lulled into a false sense of security and say, yes, of course, thank you so much for helping me, and thank you so much for giving me a way out through this litigation loan. Where do I sign? Based upon what you've previously told me, Rosie, the process, the sales process is at best rather unfair. It's opaque, lack of opportunity to study the small print, all kinds of important risks and issues are not disclosed, which means whilst the person thinks that he or she is making an informed decision, giving their consent, in reality, they haven't.
Yeah.
And because of the lack of regulation in this space, all of this has been happening to a great degree because of the massive financial incentives for the law firms to make it happen. And what we've now got is a major national scandal that you and others are desperate to expose. And that's why you're keen for people like Laura and John to get it in the press and basically blow this whole thing apart. Is
Yeah.
that basically what we're saying, Rosie?
Yes. Just one thing though, all of the people who've been sold these loans, if you look through the attendance notes or emails and correspondence, actually very, very resistant. I was saying, well, I didn't ever say yes, please go ahead. It was just done.
Really?
And with the cavity wall people, Deborah will vouch for this. There were people knocking on doors. They employed door knockers, going door to door, targeting homeowners, selling these loans. Is that correct, Deborah? People were door knocked. They were doorstepped and door knocked.
That's right. They were door knocked, but the door knockers weren't directly employed by the law firms.
Always the way.
They
Always the
sell,
way.
yeah, they sell the leads on to the law firms, and I don't think they're allowed to do that.
Yeah.
Okay.
So actually, people aren't looking for these. What else we came across was that in Novitas's, one of their annual reports, which is published on Companies House, they acknowledge quite proudly that they are training solicitors on how to sell these loans.
Yeah.
They were offering in-house training to the solicitors to sell their product.
Okay, thank you.
So
All right.
it wasn't really a market that was looking for them.
I get your point. You've helped me understand that particular nuance very well. It's an important nuance. I have a suggestion here. As we've got Laura and John here, given the professional role as journalists, perhaps Laura and John might want to ask questions to get anything clarified. Could I invite, with your permission, Rosie, could I invite Laura to take herself off mute if she'd like to, and ask any questions that you want, Laura, to get any clarification you want as a journalist. And then we'll ask John the same, okay? Laura, please take yourself off mute if you have any questions or comments. Thank you.
I don't have any particularly at the moment. I think what I'm just struggling to get my head around it is why you know, the likes of Novitas would sell so many of these loans when in terms of the CWR cases, you know, so many of them you know, weren't going to court, you know, when we're failing. Yeah, I don't really have a particular question to ask, you know, right now. I'm still trying to understand the litigation funding arena, to be honest.
Any comment, Rosie, in relation to what has just been asked about or spoken about by Laura?
We can understand very well why these loans were sold initially up to the point where they bounce into SSB law, because the lenders are actually very well protected. They've secured a charge on your home, so they have now got a charge on your home. It's a very good debt as a consequence. And it seems, from what I understand, that the same process was followed by Novitas with the Pure Legal, the High Street solicitor, Seth Lovis, Channon's, multiple other firms, all of which have gone all fallen by the wayside. But those loans appear to have been secured on good properties, you know, on people's homes. So they're effectively first charge in some cases or second charge mortgages. They win whether you win or lose in that case. What I can't understand, and I'm with Laura on this, is why they continued funding. And we've seen pitch decks that have been created by venture capitalists to attract funders into cavity wall insulation and PPI claims. These are being sold as a financial product, an investment product, by companies like Catch Investments to overseas funders who have to submit, they have to put in at least £100,000. So they're being sold as a product, and yet at the other end, there's a completely dead claim that has very little chance of ever succeeding. So I don't know if it's the venture capitalist misleading their investors, or if the investors don't really mind if it goes bust, because I guess via the insolvency, they will get their money back, but their money will have gone through a UK legal firm or insolvency practitioner before it goes back to them.
Okay.
I don't know. It's a mystery, and it's a question. It's a really good question to ask.
Thank you very much. We have a very simple practical issue right now. I've got another Zoom meeting on this channel, which I need to go onto. So we've got to draw this meeting to a close. Rosie, I'm very happy to do what I can to help. Please pop me an email with what you would like me to try to do. My hunch is you'd like to help us try to expose the unfairness of the consultation process.
Yes. And make sure it's opened up so that it doesn't focus. It's at the moment it's entirely partisan. It's a lot of, and no offense to lawyers, I know some lovely lawyers, but it's a lot of lawyers talking about a product that benefits lawyers to the exclusion of anyone that it harms. And there are thousands of people that it has harmed and will continue to harm unless proper regulation is put in place and the voices of victims and consumers are heard. Okay.
Allow me just to check an email, because it might be that my 4:30 has rearranged, in which case we can carry on. But bear with me, Rosie, while I try to do that. Okay? I don't think it has, but let me just double check. No, it's not. Okay, right. Folks, thank you very much indeed for coming to the meeting. Rosie, the simple answer is yes, happy to do what we can to help. I suggest we organise a Transparency Task Force symposium as a very sensible way to begin the process of showcasing what's been going on. We have to be very careful between explaining what's been happening, but not doing so in such a way that we get sued for doing it. But pop me an email, Rosie, and we'll talk that through, okay?
And Andy, before we go,
I'm sorry, Michelle. I'm sorry, Michelle. I've literally got to end the call now, okay? But that's okay. Michelle, please don't hesitate to pop me an email, and we'll go from there, okay?
Okay. Let's do that.
Thank you very much, folks. Thank you.
Yeah,
thank you.
bye.
Thank you. Bye-bye.
Thank you.
Bye.
Are we off this? Yes, we are. Bear with me. I'm just